The COVID-19 pandemic has seriously impacted all industries. The construction industry is no exception. What are the major problems faced by developers and contractors?
Yeah, thank you, Prem. I think because of COVID-19 pandemic, the government implemented the MCO, and as a result, all the construction, in fact, the industries across the board, except essential services, have to come to a halt, and that included the construction industry as well. And as a result, no works or physical works could be carried on at site. And eventually, it would affect the delivery date to the purchasers, especially those who have bought condominiums, apartments, residences. The developer will have to face the delay. And as a result, because as you can see under standard S&P agreements, there will be a clause whereby if there is a delay in the delivery of the vacant possession, then the developer will have to pay liquidated damages to the purchasers. Now, one of the main potential exposure to the developers is to face this LAD, or the liquidated and accident damages that may be launched by the buyers against the developers. Another potential claims that the developers will have to face is actually the claims from their own contractors. Now, because of MCO, as I said, no physical works could be carried out during the MCO period. And as you know, when there is no physical works, there would still be expenses and costs incurred by the contractors during the period. And in the meantime, there was actually no physical works. So who is going to bear the cost? And the contractors first that came to their mind is that I would like to have an extension of time because this is actually due to no fault of the contractors, and all the costs will also have to be recovered from the developers. Now, from the contractors' point of view, as I have said, even during the MCO period, when no physical works could be carried out, they will still have to expend monies, the machineries that parked at the site, and the cost to maintain the site, and a lot of financial costs exposure by the contractors as well. And depending on the size of the site, some of my clients could incur costs, as I know it, during the MCO period, up to ringgit 1 million a day. So with this cost, which was not contemplated at the time of the contract, someone will have to bear this cost, and who would that be? Now, from a contractor's point of view, of course, they would like to push the cost to the developers. Now, not only that, now, as you all know, construction industry was one of the first industry that was allowed to open and to start work. But they will also need to comply with a lot of SOPs. They have to do COVID-19 tests for their workers before they could actually commence works, and they have to implement a lot of safety procedure at site and social distancing as well for them to carry out the works at site. And all this translate into additional costs. Again, this cost was actually not contemplated at the time when they entered in contract. Who is to bear the cost? Now, even if the contractors are willing to go in, because of all these hindrances and the danger, after spending all these costs, and one of their workers get contracted with COVID-19, and the whole site will have to come to a halt again, and the retesting will have to be done, and more costs will have to be incurred. So that's why even when the construction industry was allowed to start work, after 1 or 2 months, there were only about 25% to 30% of the works have actually restarted, and the rest of them were still mulling as to whether to actually start, potentially because of this risk that they have to face, and also the cost issue, the additional cost issue that could not be resolved between the contractors and also the developers. Now, at the same time, the impact on the subcontractors would be even more, because they are normally at the bottom of the contracting chain. They are the one who actually expended monies, buy materials to bring it to the site, provide labors, and at the end of the day, they are the one who get the payment last. So because of COVID-19, and that would also have a problem, which is the delay in payment as well. And at the same time, they have already expended a lot of costs at site. So these are actually real problems faced by these people in the construction industry. And we all know that this is unprecedented. You know, COVID-19 outbreak probably happens once in 100 years. And actually, they understand the situation. But the real difficulty is that who is to bear all these additional costs and how to move forward. Thank you, Prem. Yeah.
Thanks so much, Lam. Definitely, the pandemic has caused so many issues, and we have to kind of rethink and see how we can do it. We're talking about resolving construction claims and disputes on construction projects. This is the L2 construction series, talk series we're at. Let's move on. The next question is that what could be the potential problems when you have increased costs and you have payment issues that cannot be resolved? How do you resolve these issues?
Yeah, when this issue cannot be resolved, I think the contractors will be the first to feel the heat and pressure because they are the ones who have to come up with financial resources to keep the project going. When the money finally dries up, the construction project, the progress will definitely slow down or even come to a complete halt. In this standstill, it is very likely the developer may take steps to terminate the contract because this is the fastest way for them to retake the site possession and also continue with the construction works. However, this is never an ideal solution because termination of the contract may, in the very short term and also on the surface, allow the developer to resume the construction work. But however, it may give rise to more construction problems and also cause domino effects to the construction industry. Let me give you some examples. The terminated contractor who cannot now pay his suppliers and contractors may have to go bust and close down, go out of business. And this will cause serious disruption to the lower contractual chain of the construction industry. Also, the re-tendering process of the terminated project usually takes more time and also will cost a lot more. And this would actually lead to a delay or abandonment of the project. These are the situations we have to avoid because this will affect the construction industry in a macro level. We don't want that, especially in this tough economic climate. Since these problems are inevitable or very likely to occur due to the COVID-19 pandemic, we should try our very best to manage them properly with care and not letting them to spread like wildfire. For example, when making or defending a time and cost claim, the procedural requirement under the contract must be strictly complied with. The analysis of the time delay or cost must also be properly conducted. Professionals like construction lawyer or claim consultant should be brought in at the earliest possible stage to help to resolve the problem. In addition to that, whether or not a problem or dispute can be resolved also very much dependent on the resolution forums available to them. Thank you, Prem.
Thanks so much. That was very interesting. You mentioned about forums. Could you tell us a little bit more about what are the common forums in order to resolve some of the construction claims in Malaysia?
Thank you, Prem. Well, traditionally, the commonly used forum in the resolution or for the resolution of construction claims and disputes is arbitration. And it is still the main forum for the resolution of construction disputes. But not all contracts have a construction arbitration agreement. Like, of course, arbitration agreement can be commonly found in standard form contracts, but for smaller projects and smaller contracts, they don't usually have arbitration agreement, especially for supply contracts. You don't commonly find arbitration agreements. So when there is actually no arbitration clause, then whenever there is a dispute arising from a construction contract, the parties would normally go to the courts. Now, since 2014, Malaysia has actually set up the specialist construction courts. Previous worries about whether the judges have the expertise or used to dealing with the construction matters. This has already been resolved because we have already set up a specialist construction court dealing specifically with disputes or claims arising from a construction contract. Now, on top of that, also since 2014, Parliament of Malaysia have also implemented or legislated statutory adjudication mechanism in Malaysia under Construction Industry Payment and Adjudication Act, also known as SIPA. Now, this statutory adjudication is actually a summary mechanism to deal with payment disputes arising under a construction contract, and it is done normally within a period of 4 to 5 months. The decisions would be binding. If, of course, any party who is dissatisfied with the decision can also go to the arbitration forum if there is an arbitration clause. If not, then they can still refer the same dispute to court for final resolution. Now, statutory adjudication has been quite successful if you look at the statistics. As of now, you can find about up to 900 to 1,000 cases filed in a year. Now, out of these numbers, about 70% from the statistics that I have are actually resolved at the stage of the adjudication decision, with only about 30% are eventually referred to arbitration or in court, which means the statutory adjudication under SIPA has been an effective mode of resolving payment disputes. It actually filtered out about 70% of those disputes which traditionally arose, and leaving only 30% that would only be resolved via arbitration, which is a more comprehensive, lengthy process, but it will provide a final decision. Now, apart from statutory adjudication, we also have mediation. Now, mediation, of course, needs the agreement of both parties because it has to be consensual. It is a consensual process, but also involve a third party who will be there to mediate. Now, any results that come up from mediation, normally it's more satisfactory because it would end up in an agreement, and most of the time it would also help the party to maintain the business relationship. It is less acrimonious, meaning to say that once the parties has reached an agreement via mediation, there would also be potential cooperation in the future. And it is, of course, a more amenable mode of resolution of disputes between the parties. There are also other contractual methods of resolving construction disputes, especially those involve highly technical issues, just like DAB board, a dispute adjudication board, set up under the contractual mechanism, and also expert determination. Now, the parties would like to have their specific technical issues referred to this mechanism because normally people appointed to determine these disputes are specialists in their field or related to the disputes. So they are more capable or familiar with the issues, and they will be able to resolve the specific issues or technical ones in a more effective manner. Now, this expert determination and DAB are commonly used in other jurisdictions like Australia and America and Europe, and they have actually produced very highly successful results. So Malaysia is picking up, and over the years, I also see that people are beginning to resolve disputes via DAB and also determination, expert determination. And I hope that this trend could continue because these modes of dispute mechanism are less acrimonious than arbitration or court litigation. Thank you, Prem.
It's certainly great to hear that nearly 70% of issues are resolved through education without having to go to court and arbitration. I think that's a really positive sign. I think the audience would like to know a little bit more about all the government announcements about different things that they have done to kickstart the economy and help during this pandemic. Could you tell us a little bit about some of the measures implemented by the government to help the industry move forward?
Now, one of the things that I heard from news that the government is actually mulling of extending the period of delivery of vacant possession to the purchasers. As I have mentioned earlier, one of the exposure to the developers is the delay in the delivery of vacant possession arising from the MCO, because no physical construction work could actually carry it out during the MCO period, and it actually went on for a few months. And a few months of delay in delivery of vacant possession could actually run into hundreds of thousands or tens of thousands, depending on the price of the property. Now, if the government is actually agreeable or will implement measures to extend the time for the delivery of vacant possession, that would actually ease up the burden of the developers. Now, it has to be understood that this is actually due to no fault on the part of the developer, and this is, I personally think, is a welcome measure to help the developers so that they can also concentrate in expediting the delivery of the product, like the condominiums and also residences. Now, the other part, our measure, which not only apply to construction industry but apply across the board, is the extension of the statutory demand notice period. Normally, under the rules, the winding up rules, before a party can actually present a winding up petition, one of the methods of doing that is to present or serve a statutory demand notice on the debtor, giving them 21 days to pay up. Now, if they fail to pay up, then the creditor can actually proceed to present a winding up petition in court to try to wind up the company or the debtor company. Now, the government has actually extended that period from 21 days to 6 months, meaning to say that the debtor will have a longer period to satisfy the payment under the statutory demand, and in a way that it actually gives them a more breather space for them to organize their finances. But one of the downside of that is actually, those people, as I said, at the bottom chain of the contracting chain, those people who have actually expended the money, bought materials and installed at the site, but at the same time, they are actually facing delay in the recovery process of payment. So they are the people who are the most affected as a result of this measure. And I also understand that at the moment, there is a case that is brought to the court to challenge the validity of this interim measure that has already been implemented by the government, and we will have to see what will be the outcome. Thanks, Prem.
That's great to know. I'm sure the industry appreciates the support they're getting in helping, giving them more time to resolve these sort of issues. Going forward, can you tell us a little bit more about what other projects L2 is working on now?
Thank you, Prem. Well, L2 Icon, again, was an idea that crops up during the MCO when we were doing the L2 construction series. What we realized is that, you see, via L2 construction series, we managed to bring in together about 42 people with different expertise and background. And we realized that if that happens in a particular platform, that you can provide services via one center, meaning to say that you have a one-stop center that provides all these diverse expertise and advisors that relates to the construction industry, that would actually help the users in the delivery of these services, and without having had to ask the user to source for this expertise from different platforms or through different recommendations. They can actually source those expertise via this one platform, and we call it the L2 Icon. And the platform, as I said, will have a community of people from different backgrounds with different expertise who will be able to provide legal contractual advice and also technological and project management for construction projects.
Thanks so much. I think that sounds really interesting that you're launching this platform. Could you tell us a little bit about what areas of expertise the L2 Icon will be providing to the users?
Like what Wai said, with the concept of one-stop center solution, we are looking at 5 areas: training, alternative dispute resolution or ADR services, construction technology, technical evaluation, and contract administration. For training, we actually have a lot of good trainers in our construction industry. We can bring them all in onto the platform to conduct webinar and on-site conference on education in the field of ADR services and also construction issues. Similarly, we have a lot of very good and knowledgeable, very professional practitioners in the areas of ADR services, contract management, technical evaluation, such as the QS services, defect evaluation, design assessment, and delay analysis. We will bring all these tip-top professionals so that they are onto the L2 platform so that they are within the reach of the people that really need them. Construction technology has been around for a while now. The COVID-19 pandemic crisis has just fast-tracked the digital revolution. Construction technology will definitely be part of the construction process in the future, and that's why we have included it as one of our areas. Look, L2 Icon is an ambitious project, and it will be benefiting to the construction community. Both of us really want to do it right. We want to get the right mechanism, the right formula, the right strategy, and definitely the right people. That would be our vision. It is a long-term project. Thank you.
Thanks so much. That was really interesting. Now let's check out some of the questions coming to us from Zoom and Facebook. We have a question here directed to Leon. And the question is, how can I proceed through SIPA when there's no director appointed at AIAC? Can you tell us a little bit about how this happens?
Under the SIPA Act, also the AIAC rules and regulation for the SIPA adjudication, you actually need the notice of adjudication is actually have to serve on the director of the AIAC. So in the present circumstance, there's the new director has not been appointed yet. So technically we can't proceed with the SIPA adjudication, but we still can file the first SIPA payment claim, which we call Form 1. Then pending the new director to be appointed, only then we can proceed. So in short, we can only file the payment claim as of now. Thank you, Prem.
Okay, thanks so much. We also have a question directed to Lam. The question is, can a developer file a law case against a contractor if the project is delayed due to COVID-19?
No, I think it is not about filing a law case because the rights of the parties are normally governed by the contract. And for example, if COVID-19 actually caused a delay, the first thing that the contractor would do is to ask for extension of time. Now, people are actually talking about force majeure, whether force majeure would cover COVID-19 pandemic, but it's actually not necessarily so. Because the term force majeure is also dependent on how wide the definition is drafted in the contract. Some contracts definition that defines force majeure in a very restrictive manner that actually does not include pandemic. So in such a situation, then the contractor would not have an avenue to apply for extension of time under force majeure. Then they will have to look at other clauses under the construction contract to see whether they can actually, through other indirect means arising from the COVID-19, to help them to apply for extension of time. Now, the reason why the contractor wants to ask for an extension of time is to relieve them from the exposure to liquidated and accident damages as a result of the delay in the completion of the project. So if this issue cannot be resolved, and eventually if the contractor is charged with liquidated and accident damages, then the employer or the developer can exercise their rights under the contract to withhold money for the works done as a deduction towards the liquidated and accident damages. Thank you, Prem.
Thanks so much. So before we end today's session, are there any points, Mr. Leong, Mr. Lam, you want to bring up to advise our viewers?
Now, thank you, Prem. I think the parting message is this. COVID-19, as I've said, is an unprecedented occasion, which was actually not contemplated by the parties, even at the time of the contract. So when these things happen, I don't think that parties should only look at the contractual provisions strictly and try to have only one party winning solution. Now, like for example, the additional cost might not be covered under the contract. So in order for you to move forward, how are you going to resolve this additional cost issue? Would the developer be willing to cover at least 30% or 40% or even half of the cost to help the contractor to at least kickstart the project first, and we can actually deal with it at the final account stage as to how to resolve the additional payment issues. Now, I actually can see that some of the developers actually take a very hard stand by just looking at the contractual provisions and stubbornly insisting that I'm not going to cover this cost. This cost would have to be borne by the contractors. And from the contractor point of view, they think that before I can actually start work, I have to spend hundreds of thousands. And at the same time, even if I have started work, I may be exposed to further costs if one of the workers get contracted with COVID-19. Now, when those hard stands are taken, you can actually see the suspicion is created, and also the one-way street imposition of a burden on a particular party, and which would ultimately resulted in the unwillingness to proceed with the works effectively. And who is going to suffer at the end of the day? It would also be the developer, or even the purchasers will be suffering. So in order to resolve this unprecedented issue, I think parties must have a cooperative mind, facilitative mind, to try to resolve the issue on the ground, to be less contractual, but more of practical thinking, in the sense that I just want to resolve the issues together, and we can sail through this pandemic problems together, and we can actually eventually survive the pandemic. So I think with that kind of a mindset, a mediating mindset, it would actually help to resolve the problems more. As I said, don't be too legalistic, don't be too contractual, but more pragmatic and practical.
Thanks so much. I think that was really an informative sharing session. I understand we had some audio issues in the beginning. Sorry about it. But this video will be available online, and you can always come and watch it in case you missed certain parts. So lastly, thank you to Mr. Lam and Mr. Yong for sharing your insights, and the possible solutions whenever you have a problem in the construction industry. It's really been insightful. I've learned a lot. If you have any further questions for our speakers, please refer to the Google form link pinned on the comment section, and our team will get back to you on those questions. So thank you very much to all our sponsors, all our supporters, and L2 for bringing this session. Thank you once again, and do join us for the next talk for the Property Outlook for 2020 and Beyond Talk series. Stay tuned, and we'll be back between July and September. Thank you.
Thank you, Prem, and thank you, everyone.
Yes, thank you, Prem. Thank you, everyone, for tuning in.
Hello, everyone. I'm Florence.
And I'm Azlan.
Thank you for tuning in, and we hope you enjoyed the first of the 6 live sessions brought to you by the Malaysian Property.
Yes, there will be more to come.
We would like to thank our moderator, Mr. Premish Chandran, and our 2 speakers, who are also the founders of the L2 Construction series, Mr. Lam Wai Loon and Mr. Leong Hong Kit. We are so excited to see what's in store for their next project and wish them every success in their journey.
Yes, Florence, and also a big thank you to our Facebook partner, Malaysia Kini, our supporting organizations, and all partners.
Aslan, do you know what's the topic for our next session?
Yes, Florence. In the old days, our property buyers will make their purchases at sales galleries and offices. But now, since tech-savvy millennials are the largest group of property buyers, and the process of buying properties has shifted to suit the digital revolution.
Virtual sales galleries, virtual property viewing, online booking. Property technology, aka PropTech, is at its height now, and buying property just a clicks away. However, home buyers must be careful throughout the process. Better be safe than sorry, right?
Exactly, Florence. In our next session, we will discuss and explore the steps leading up to purchasing a property online in Malaysia.
Yes, come join us on 18 July at 11 a.m. for the latest information about the online property market. You can also register by scanning the QR code or simply check out our social media platforms.
Hope to have you with us and thank you for your time. See you next time. Bye.